Okay, that's good. All right, so we'll get started so we can get you out of here on time as well. And so, as Ellen said, I'm Mary Murphy. I come from the whole way from Ireland today to talk to you about GDPR and privacy by design, and I'm really pleased to be here. My background is that I'm an engineer. I worked in telecoms for a very long time. In fact, I've been in Tel Aviv before with Motorola. So I believe in an operational approach to privacy. I believe that, if you leave it just up to the lawyers, it's not going to work. It has to be a holistic approach, and you have to involve everybody in privacy. So that's where I'm coming from. I'm an accredited data protection officer, so I know a little bit about what I'm talking about. And this session, I'm doing a total of 4 sessions in total over the next couple of days. And you'll be coming to one or more of them, I guess. This is the introductory session. It's very high level. It's really fast, and it's really to give you a feeling for what is data protection all about, what are the key definitions, what's privacy by design about, what is the GDPR about that people should have heard about. Have you all heard about the GDPR? Yes, okay, so that's why you're in the room. So it's very high level, it's a lecture style. I don't have exercises because there's so many of you in the room and because we only have 90 minutes. The next session is about data protection impact assessments. Data protection impact assessment is a key tool in data protection practice, and it's a key part of a privacy by design program. And it's all about risk and compliance, so evaluating, identifying data protection risks and figuring out how you're going to address those risks. And that's going to be much more of a workshop. We have 2 case studies in it, and it's also 90 minutes. Session 3 is a 60-minute workshop, and we're just talking about what are the specific risks for data protection when you're doing analytics. And then session 4 is looking at cloud computing and what are the specific risks. So, if you've gone through the high level, the risk analysis, and then these look at the specific risks, and they're much shorter. And I think a lot of you are going to come to this one, the cloud computing one. Okay. So we're on session 1. In this session, you can see I'm going to cover a lot of material. I'm doing a very brief review of data protection law because you need to know what the definitions are, you need to know what the principles are. We'll do an introduction to privacy by design. Where did this come from and how does it fit into data protection law? We'll talk about the General Data Protection Regulation, or GDPR, and where that is coming from and what's changing in the GDPR, and then how privacy by design is addressed in the GDPR. And then we'll talk a little bit about privacy by design in operations and how do you go about thinking about privacy by design when you're implementing software engineering products. So again, all very, very high level. Just to set the expectations about what I will and won't do. So I'm a privacy expert. I have a knowledge, because of my background in engineering, of product development lifecycle, but I'm not an expert. You guys are the experts. My role is to highlight the privacy concepts. It's your role to figure out what are the appropriate technical solutions and how do you embed that into your development process. So I'm not here to tell you what to do. I'm just telling you how to identify what problems might be there, and you're the guys who will come up with the solutions. So just talking about data protection. So the first thing is that the EU General Data Protection Regulation is coming into force on the 25th of May next year. And this is a really significant thing because this is an update of the EU Data Protection Regulation. The previous Data Protection Regulation, which is the European Directive of 1995, was published 3 months before the first internet service was launched, the first public internet service, which was AOL. So our existing data protection regulation or legislation predates the internet. And it predates, since the internet, what we do with our data has changed almost unrecognizably. We have smartphones, we share stuff, we have social media, we have, all of those things didn't exist the last time the regulation came in. So one of the main drivers of the EU data protection regulation is bringing data protection regulation into the internet age and dealing with how we actually share our data and how we actually use our data now. So we'll talk a little bit more about that as we go through. The related regulation that you should know about also is the e-privacy regulation, which it's not as old as the current legislation on data protection. It dates back about to 2011, but it's still a little bit out of date and it's a little bit clunky. So they're bringing it up to date to be consistent with some of the stuff that's in GDPR. And the main thing about the e-privacy regulation, so GDPR addresses how we deal with personal data and how we process personal data. And e-privacy regulation is all about electronic communications and regulations around electronic communication. So the e-privacy regulation will deal with any interactions that we have and any communications that we do online, whether in a personal capacity or a business capacity. So this has, for businesses that don't process very much personal data, this has quite a lot of implications. And we'll talk a little bit about what's changing there as well. So I'm going to start off with some very high-level data protection definitions. And the first definition is, what is personal data? Obviously, you need to know what personal data is in order to protect it. So the key thing is that a lot of people are very surprised at how wide-ranging personal data is. And it's any data that relates to a living person. So that's a living identifiable or identified person. So identified person is easy because that is, I'm identified by my name and my address, or I'm identified by my tax number, or I'm identified by my employee number at work. And that makes me identified. But identifiable is, you don't have to be identified by name to be an identifiable person. So it's maybe pieces of information about you that added together can only track back just to you. So for instance, if you go out and you buy a new Android phone and you turn on GPS tracking, and after about 2 days you look at your phone and you'll be told, here's your home address and here's your work address, because by the patterns of where you go and where you spent your night and where you spent your time from 9 to 5, Google will have worked out that your home address is this place and your work address is this place. And for most of us, that will trace us back to a single identifiable person, because I'm the only person who lives in my house and works in the same office that I work in. So that makes me identifiable. So you don't have to be identified just to be identifiable, and you're protected by data protection laws. And then any data that is generated about us, about our preferences, about our behaviours, about where we live, about what we shop, about how much we earn, any data at all is data that is protected is personal data and is protected under data protection laws. Then there's special categories of personal data or sensitive personal data. And these ones are data about racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership. Genetic data and biometric data are new, so all the others that are here listed here are protected under current legislation. But genetic data and biometric data come in under GDPR and they're new. And the reason that they come in under GDPR is 22 years ago, when the existing legislation was brought up, we weren't processing genetic data the way we are processing it now, and we didn't have the capabilities to process biometric data the way we do now. We didn't have facial recognition software, we didn't have fingerprint scanning at work. All of that stuff that's possible now wasn't possible on the same scale 20 odd years ago. Data concerning health and data concerning your sex life or sexual orientation is special categories of personal data. Now, I know from what Ex Libris does that you don't process special categories of personal data. So you need to know that they exist in case that you ever think about processing them. But if you're processing special categories of personal data, there's additional safeguards that you need to be aware of, and there's additional checks and balances that you need to put in place. And we're not going to go through those today because you don't process those categories of data. So data subject, it's you and me. And these are the roles. A data subject is us, and again, identified or identifiable. A data controller is a company or an organization who determines the purposes and means of processing. So the data controller decides what's going to happen to data. And they may process that data or they may not process that data. They may outsource that processing. And then a data processor processes data on behalf of a controller. And then that's a very, very important relationship in data protection, that relationship between the data controller and the data processor. And it's a contractual relationship. And there must be a contract between the data controller and the data processor. And you guys, again, Ex Libris is a data processor. In terms of your core business, you're a data processor. So you will be, all of your customers are data controllers. They're determining what happens to the data and how you process the data. They decide to outsource their data processing to you. You're processing data as a data processor under contract. So the key thing for you guys is that you don't exceed the terms of the contract, that you process and you keep within the terms of contracts that you have with your data controllers. So that's that relationship. The rule of thumb I use for determining if you're a data controller or a data processor is if you didn't exist, would the data still be processed? And it works. I haven't yet been in a situation where it doesn't work, and it's a kind of a nice simple test that you can use. And that is, so in your situation, if the universities who would be your customers, if they didn't exist, then that there would be no need to process any student data. Whereas if Ex Libris didn't exist, maybe the library data would be processed in a different way, or processed by a different company, or processed by the university, but it would still need to be processed. So that's how you test that controller processor. The other thing is that every company is a controller in respect to its employees, and every company is a controller in respect to your own customers. So any personal data that you process as a result of dealing directly with your customers is you are a controller in respect to that personal data. But in your core processing activities, which is processing data for the library services for the universities on behalf of your customers, you're a data processor. I forgot to say, if you want to ask any questions, just put your hand up, feel free, because I go through this stuff very quickly, and you know, stop me and ask.
Is the air conditioning on? I just wanted to cool.
Is it getting very warm? Yeah. Bring it down a bit. Okay. Okay. Everybody okay so far on that, on the definitions? Okay. And then processing is anything that's done to data. And this is kind of, in some ways, there's a big long list of what you can do to data here, but in some ways this is a very simple definition, because from the moment you collect the data until the moment you delete the data, including the act of deleting the data, anything that you do to the data is processing the data. And I was doing some work with a company last week, and I was asking them about data processors. And they were saying, oh, we've no data processors. And I was saying, but I thought that you had a call center that did some work for you. And they said, yes, but they log into our systems. So, you know, they're not a data processor. And I was saying, actually, no, they log into your system. So they use and they consult, and often they update the information on your systems. So they're still processing the data, even though the data hasn't physically been shared with them. They're still using that data and using that information, so they're still processing the data. So that's processing. The act of deleting is a very important one, and it's one that doesn't happen all the time with data. So the data protection principles, these are the principles that are in the GDPR. There's not a huge change in the principles from the existing data protection legislation that's in place in Europe. The big difference is that everything is being harmonized. So there's 6 principles. They're going to be the same principles in every country in Europe. At the moment, we have 8 principles in Ireland, and in the UK, they have 8 principles, but there are different 8 principles, you know, and they're hard to map to each other. So the first principle is the principle of transparency, and that says that data must be processed fairly, lawfully, and in a transparent manner. So the fairly bit is that if I collect data for a purpose, anything that I do with that data must be consistent with with the purpose that it was collected for. So if I collect data for the purpose of paying your salary and I suddenly start marketing to you about something completely different, then that's not consistent with the purpose. So it's not a fair processing of the data. Lawfully, I will cover in another slide, but it means that you have to have a legal basis for processing data. And a lot of people think that because data is publicly available, you can just process it. But actually you can't. You have to have a legal reason and a legal, legitimate basis for processing all data. And then the transparent manner is really important. It means that you must communicate to the data subject what you are going to do with the data. You need to be very, very clear, and you need to be very transparent about what you do with the data. Now, as a data processor, you guys aren't responsible for ensuring that the data is processed fairly, lawfully, in a transparent manner. The data controller is responsible for that. But you're responsible for making sure that you have functionality and capabilities in your software that enable the data controller to process the data fairly, lawfully, and in a transparent manner. And your lawful basis for processing will be a contract. It will be because you're a data processor, it'll be the contract that you have with the data controller. So that's the first principle. The second principle is that data must be collected for specific, explicit, and legitimate purposes. So again, it's back to transparency, because if you don't know what you're going to do with the data, you can't explain it to the data subject. So I think these are inextricably linked. But specific, explicit, and legitimate purposes mean that at the time that you're collecting the data, you need to know what you're going to do with it. And you can't collect data that you don't need for those purposes. And you can't repurpose data later. So a lot of companies at the moment do say, well, look, let's collect this because it'll come in useful sometime, and we don't know what we'll do with it, but we'll collect it anyway because it might be useful later on. You can't really do that, and you can't do that under GDPR. It has to be specific, explicit, and legitimate. Adequate, the third one is adequate, relevant, and limited to what is necessary to meet the purpose. So the data has to be relevant to the reason for processing. It has to be it has to be data that's necessary to carry out whatever processing that you're carrying out. But it also, limited to what is necessary to meet the purposes, I think there's 4 things that you need to limit. You need to limit what data you collect. You need to limit how long you keep it for. You need to limit what processing you do on it. And you need to limit who it gets shared with. So it should only be shared with people who need it. It should only be kept for as long as it's necessary for the purpose. It should only be processed with activities that are required to carry out the purpose, and you should only collect the data that you need for the purpose. Keeping it accurate and up to date is the next principle, and that's fairly kind of an obvious one, that if you collect the data, you need to keep it accurate and up to date. So again, as data processors, the requirement on you is to provide mechanisms in your tools and in your software for people to be able to keep their information up to date. So either for the data controllers to be able to keep the information up to date, or ideally for the end users to be able to keep their information up to date. And this one's important for data subjects because information gets out of date and it can cause harm to the data subjects. So for instance, if you have bank statements and you move address, and your bank still is sending all your financial information to your old address, that can, the person who's living at your old address can, do things with your financial information that you may not wish them to do with your financial information. So it's that kind of thing. If you're going through a recruitment process with a company and you send them your CV, 6 months later your CV is out of date because you've completed a course on data protection and it should be on your CV. Information gets out of date very quickly because we move on, we do things. So it's keeping it accurate and up to date is important. Kept secure to maintain integrity and confidentiality. It's kind of an obvious one again. If you have the data, you have a responsibility to keep it secure. The language that's here interests me because they're using the language of the ISO 27001. And what I think the subtle message that's coming through in the GDPR is to push companies towards the use of security frameworks. And I know you're all ISO 27001 compliant, which is really good. But there's a lot of companies, and I would go into a lot of companies where the security is very ad hoc. You know, they haven't done a proper structured security assessment. They haven't looked at, you know, the discipline that comes with using a security framework isn't there. So it's whoever came in as the salesman who came in and pitched the best security solution to them is what they use, rather than looking at the risks to the data. What could go wrong? What do they need to secure? What are they securing it against? What are the threats? You know, the ISO puts that discipline in there. So I think it's interesting that they're using that language in the GDPR. Must not be kept for longer than is necessary is all about data retention, and it's something that I think most companies are pretty have opportunities, shall we say, to improve their data retention policies. And I think we're all hoarders. We all keep information in case it might be useful later. And it's hard to let go of it, but actually you shouldn't be keeping it for longer than is necessary. And then this is a very, very big shift in the GDPR, and this is why a lot of companies are sitting up and taking note of GDPR and thinking about how are they going to become compliant. At the moment, if you're a data processor or a data controller in Ireland and in England, and I think in most of Europe, what you need to do is register with the Data Protection Authority in your country. And so you register every year, you tell them a little bit, a paragraph of information about what you do, and that's your obligations met as a data processor, or your official obligations met. This is now saying that controllers and processors must be able to demonstrate compliance. That means you have to have documentary evidence. And it's not just evidence of I was compliant today, it's evidence of ongoing compliance. And that's why, you know, doing stuff like this kind of training is going to be really important for this ability to demonstrate compliance. It's a huge shift in GDPR, yes.
So I think it's quite like it's not well defined. I mean, the necessary, longer than necessary. Are there strict definitions about what is necessary and what is not, or
no.
what we need to follow or not?
Yeah. Yeah, no, there aren't. Is the short answer. It frustrates a lot of people. Must not be kept for longer than necessary. A lot of people say, just tell me how long, and I'll delete it at the end of it. But you know, this is trying to regulate a lot of different businesses who process data for a lot of different purposes, and there's a lot of different reasons why you might need to keep data. So, for instance, if you're collecting taxation data on your employees, there's probably a regulation in Ireland. There's a regulation there that says you must keep that data for 6 years, and so you have to take account of external regulation, and then you have to take account of the business need. But the keeping for longer than is necessary, the way to meet that regulation is to sit down and look at what data you have, and figure out what the regulations are, and then figure out the business need for anything that doesn't come directly under a regulation. Figure out the business need, and then determine and document how long you're going to keep the data. But certainly, I know that there's a case in Ireland of somebody did a subject access request, and it was with the civil service recruitment team, and their CV was on file since 1973. So that's a little bit longer than necessary, you know, and so I think companies have the discipline of deleting data and of being, you know, looking at data and saying, am I finished with it? And can I get rid of some of this? It's become so much easier to store data for longer, and the boundaries of, you know, that force us to delete data because we have to make space for the next data coming in, they're going away. And so a lot of companies will have a lot of challenges to actually meet that one. But again, for you guys as processors, you need to ensure the data controller decides how long is necessary. That's not your decision. It's the data controller who decides that. Now you can encourage them, and I know there was a question in the last class about, you know, encouraging them not to port too much data into, you know, with new customers, not to port too much old data into your systems. But what you have to do as data controllers is give them the ability to delete the data, or the ability to implement retention policies in their software, in your software. So e-privacy, just a quick summary on this. So at the moment, the e-privacy regulations just apply to telecom service providers and internet service providers directly. So what they're doing is they're changing the scope to bring in what they call the over-the-top providers. So the Viber and the Facebook messaging and all of those services, communication services that go over the top of traditional internet services and telecom services. So the scope is changing. There's a clause in there to guarantee the confidentiality of communications, which is quite important. Cookies, I don't know if it happens here, but in Europe, if you open a web browser, you get a banner that says, this site uses cookies, please accept the use of cookies. And there's a thing called cookie banner fatigue, because every site uses cookies. So it's meaningless. It's a meaningless notification. And what they want to do is, there's two types of cookies. There's the sessional cookies and there's the persistent cookies. And they want to warn us about persistent cookies. And they want to give us notification when a cookie is going to be placed on our machine and it's going to stay there and hang around and track us around the internet for a very long period of time. That's what they want. And the other thing that they're trying to do is to centralize consent in software so that you set up your preferences in your browser, and then every website that you visit will respect those preferences. So that's where they're going with the cookie rules. Marketing, this causes a lot of consternation for salespeople because direct marketing and cold calls are prohibited. So you can't market to people without their consent. And there's a lot of, GDPR has some very strict definitions on consent, and they're going to be imported into the e-privacy regulations as well. So that's going to cause a little bit of consternation for people, I think. And then fines are consistent with the fines in GDPR. So everybody has heard about the GDPR fines, 4% of global turnover or 20 million euros. And really, the fines are there to focus companies to think about this, rather than, I think, to be fines. So I'm a big fan of Dilbert, so I just had to include a little bit of Dilbert here. I used to work for Motorola, and in Motorola, Motorola was famous for coming out with, it was a big corporation, and they'd come out with these big statements of what all the employees need to do, and the next day they'd be in Dilbert, and sometimes the very same day. So we suspected that there was somebody on the board of Motorola who was a big fan of Dilbert, used to pick up the phone and pass all this stuff. Who here has a special email for when they're asked for marketing emails? Because a lot of people do. Lots of people, yeah, lots of people. So now we're on to privacy by design. So that was data protection. So privacy by design has been around for a surprising long time. It's been around since about 1995. And it was brought in by, the concept was first launched by this woman called Anne Kevokian. And she's actually very interesting. She was the Data Protection Commissioner in Ontario in Canada. But she has a background she is a psychologist, and she's Dr. Anne Kevokian. She's a doctorate in psychology, and she went to work in the public sector. And her interest was in how the psychology of law, how do you apply law in practice, in principle, and what's that psychology that's required to apply laws in principle. And then she went back and she did a law degree as well, and I think a doctorate in law. So I think she's Dr. Anne Kevokian, but she came up with the concept of privacy by design in 1995, and she's been pushing it for a very long time. So in 2006, it was adopted as part of a global privacy standard. In 2009, it was adopted in the Madrid Resolution, so that was adopted by the European privacy authorities. In 2010, it was adopted. Now, this adoption is called it was a global adoption of the concepts of privacy by design at a meeting of all the data protection supervisory authorities globally, which was held in Jerusalem. So there's a Jerusalem connection for privacy by design. In 2011, it was adopted into the